Hello, everybody, and welcome to the National Employment Law Center, the National Employment Law Project and the Student Bar Protection Center's webinar on trading repayment agreement provisions or traps. I'm going to give this a couple minutes for folks to trickle in, just welcoming everybody and letting you know that we're going to get started probably about 2 minutes past the half-hour point, depending on what time zone you are in. So it's 2:32 East Coast time, and welcome. All right, we are 2 minutes past the half-hour mark, and we are going to get rolling here. Thank you, and welcome everybody to the National Employment Law Project and the Student Bar Protection Center's webinar on trading repayment agreement provisions, or TRAPs. We are really excited for an incredible program here full of experts. We are going to hear from an all-star lineup here, including special remarks from my friend and longtime colleague, Martha Fulford from the Colorado Attorney General's Office. I wanted to open up first by thanking our partners here for co-sponsoring this event, along with a series of deep dives that we have posted on the National Employment Law Project website and on the Student Bar Protection Center's website, written by a number of our panelists here over the course of the past few weeks. Diving into training repayment agreement provisions, or TRAPs. TRAPs are a specific flavor of employer-driven debt that are used to tie people to their workplace, often just trumped up as a justification for locking people in place, but tied to training or other kinds of education offered by an employer. This feature of a workplace contract grabbed headlines almost 2 years ago when our colleagues here from Towards Justice joined the Student Bar Protection Center and Jubilee Legal to sue PetSmart for locking its pet groomers into these so-called traps. That was just the kind of first big public attention to an issue that has really grown since then. We have seen the Biden-Harris administration grab this issue and drive oversight at the Consumer Financial Protection Bureau, enforcement at the National Labor Relations Board, and in the Solicitor's Office at the Department of Labor. We have also seen states step into the breach and fight for people that are laboring under these traps. This is great progress, but there's lots more that can be done. The theme of today is going to be state and local action to help address these problems. That's also been the theme of the public writing that we've published over the past few weeks. So we are excited to share all of this and more. Just today, we've released a new toolkit helping state and local policymakers be able to take action here, ranging from state attorneys general to state financial regulators to state lawmakers. So more to come from the Student Bar Protection Center and our partners. My name is Mike Pierce. I'm the executive director of the Student Bar Protection Center, and I'm joined here by my friend and longtime collaborator, Terry Gerstein at the NYU Wagner Labor Initiative. And Terry is going to be moderating today's conversation. Terry's actually the first person that I ever heard talk about training repayment agreement provisions and the use of debt in the workplace, sitting at the intersection between consumer law and labor law. She is the director of the newly created NYU Wagner Labor Initiative at NYU's Robert F. Wagner Graduate School of Public Service, where she works with the state and local government. Works with state and local governments to help them protect workers' rights. Previously, Terry worked at the Harvard Center for Labor and a Just Economy and the Economic Policy Institute. She enforced labor laws for many years in New York, including as Labor Bureau Chief in the Attorney General's Office. She writes and speaks frequently on worker issues with op-eds in the New York Times, Slate, CNN, and many other outlets. With that, I'm happy to hand this over to Terry, who's going to moderate our panel. Thank you so much, Terry.
Thank you, Mike, and thank you for inviting me to moderate this really interesting and important panel. So I'm just going to offer a couple of initial framing thoughts and then introduce our panelists. So you already heard a little bit from Mike about training repayment agreements, which are one kind of stay or pay contracts. Stay or pay contracts basically make workers pay money if they want to leave their jobs. This is something that reduces worker mobility, suppresses wages. It's also, can keep people from reporting violations of the law if they feel stuck in that way. And it's just blatantly unfair that people should have to pay a whole bucket of money in order to leave their jobs. And I've been in this field for a long time, and it's always interesting to me to see how there are new forms of exploitation and new ways of sort of circumventing the law and suppressing workers' rights. And I think, as Mike said, it's so important for state and local enforcers who are often very nimble and at the forefront and cutting edge of addressing new issues. It's really important to be nimble and be able to kind of think about how to use powers in a way to address these new and emerging developments that are really oppressive for people. So I'm really excited to help moderate this conversation, and also excited about all of the possibilities for state and local action to make a difference in this area. So our panelists today, in alphabetical order, we have Rachel Dempsey, who is an attorney at Towards Justice in Denver, Colorado. Her practice is focused on all forms of employee representation and advocacy. She is counsel for plaintiffs in TRAP cases against PetSmart, which we've already heard of and we'll hear more about, the commuter airline Southern Airways Express, and the IT staffing agency SmoothStack, among others. Daniel Henley is a senior legal analyst at the Open Markets Institute. His work focuses on fair competition and antitrust law. He authors op-eds and law review articles advocating for aggressive enforcement of the antitrust laws. Jonathan Harris is a senior fellow with the Student Borrower Protection Center and an associate professor at LMU Loyola Law School, Los Angeles. He teaches contracts, employment law, and labor law, and he authored a law review article that exposed the dangers of traps. And Candace Lofton is counsel at the Student Borrower Protection Center. She focuses on litigation involving traps and other consumer issues. So we're going to start out, you've already had a little bit of a definition of traps, but we're going to start out turning to Jonathan for getting in a little bit more depth about what are traps and why are they increasing in use right now.
Well, thanks, Terry, and thanks, NELP and SBPC for having me. So, as Mike said, training repayment agreement provisions, traps, really are used to lock workers into jobs by using the justification of training, saying that workers have to pay back to their employer the cost of their so-called training if they leave before a certain period of time. Now, this training is oftentimes doubtful at best in terms of the quality or the value that it's giving to the employee. And research that some colleagues of mine have done has shown that employers oftentimes use traps not to give quality training to their employees, but instead simply to lock workers into their jobs. And a lot of times those jobs end up being pretty bad. These contracts are typically buried into a pile of onboarding paperwork that workers are required to sign on the first day of the job. There oftentimes is no justification for the costs that the employer has decided that the worker would have to pay in order to leave. And a lot of times they include interest and attorney's fees if the worker leaves. And of course, this means there are lots of consequences for the worker well beyond the workplace, including the possibility of hurting their credit reports or losing housing or other benefits. Let me actually give you an example of how these traps work in a way that I think could help shine the light on what's going on here. Mike mentioned PetSmart, and the lead plaintiff in that case is named Brianne Scally. And in her case, she was hired as a pet groomer. She loves dogs, and she wanted to work as a groomer at PetSmart, and she was only paid about minimum wage for the job. And when she started, she had to sign a trap. And the trap said that if she left within 2 years, I think, that she would have to pay $5,000 for her so-called training to PetSmart, as well as another $500 for the tools that they made her buy for the job. And so what was this training that she got? Well, a lot of it was sitting her in front of, according to her lawsuit, sitting her in front of the computer and watching online training modules, and then sending her pretty quickly out to start grooming paying customers' pets. So when she left, she got this bill in the mail from a debt collector saying she owed $5,500 and really had no idea what to do, and obviously was devastated by it. Now, you might be thinking, okay, this is a debt that workers have to pay off in order to leave their jobs free and clear. This sounds like indentured servitude. Am I crazy here? Didn't the 13th Amendment take care of this? And you're not crazy. Actually, 2 separate judges at least have said that these traps work akin to indentured servitude. And more workers are finding themselves under traps, especially now as it's harder for employers to find workers willing to work at the wages that they're offering, as well as heightened scrutiny on traditional non-compete agreements that are used to also keep workers from leaving. Let me repeat this. We've seen a lot of talk about non-compete agreements and how regulators are cracking down on them. Traps are now being used as workarounds to those. Employers are seeing the writing on the wall, and they're saying, what's another way we can keep our workers from leaving without using a traditional non-compete? Traps is what they're turning to. A study last year showed somewhere between 1 in 10 and 1 in 13 workers in the US are now working under traps. Another study showed almost half of new registered nurses have traps in this country now. So this is a major problem.
And Jonathan, I remember one time you and I were talking about traps, and you pointed out that in some ways they're worse than a non-compete, because a non-compete, you can't work in your own field for a set period of time in your geographic area. But a trap, if suddenly you owe $20,000, that can prevent you from leaving to get any other job anywhere. So they really are, so oppressive to workers. Can I just ask you one more quick question, though? Like, is there any validity to the argument that workers are getting valuable training out of these that's sort of transferable to other employers? Or is this employers just trying to make workers pay for the on-the-job training that workers have gotten since time immemorial, just as part of starting a job?
Yeah, I mean, I think it's important to keep it in context here. Historically, employers have offered training to their workers without strings attached. It's just been part of the employment contract.
The deal, right?
And all of a sudden, we're seeing this and other ways that employers are saying, "Hey, we need to get our money back." But when research has been done questioning employers about why they use traps, the number one answer is not, we want to have high quality trained workers and we want to preserve our investment in that. It is, we want to find a way to keep our workers from leaving. And I think that's the central focus here.
Thanks, Jonathan. So let's bring Rachel in. Rachel, there are other forms of stay or pay contracts as well, not just traps. What are some of the other forms of stay or pay contracts? And also, how do wage and hour laws come into play in relation to any of this?
So as you said, Terry, I think in your introduction, a stay or pay contract is any kind of debt or penalty you have to pay in order to leave your job. So training debt is one way that employers frame this debt, but other contracts require you to repay equipment loans or for foreign workers, for workers who come into the country on a contract that requires them to get immigration status, immigration costs, sometimes costs for like an orientation program. Sometimes employers will try to recover just like the value of job experience on the market, or the employer's lost profits from not having their employees work for as long as they wanted them to. Or the cost of hiring a replacement employee. Sometimes they're in the form of liquidated damages and sometimes actual damages. And I think it's important to emphasize in the context of these, talking about traps. I think traps have gotten the most attention. But I don't think we really solve this problem unless we look at the issue more sort of holistically. Because employers can call these debts whatever they want, right? A lot of them are sort of made up anyway, as Jonathan sort of explained, I think, with traps. And so you make training repayment illegal, then they'll be like, okay, fine, we're charging you for lost profits, or the cost of hiring your replacement or whatever. So I do think it's important to think of this issue broadly. And I think to that point, one of the ways that that Towards Justice has been attacking this issue is through wage and hour law. So the wage and hour law, the federal wage and hour law, and I think a lot of state wage and hour laws as well, you're not just required to pay employees minimum wage. The employees have to keep the minimum wage that you pay them. That sounds obvious, but it's not in the case of these stair pay contracts. So under one of the implementing regulations of the Fair Labor Standards Act, 29 CFR 531.35, it says sort of explicitly that wages can't be considered to have been paid unless they're paid finally and unconditionally or free and clear. And so that gives rise, I think, to claims under two theories that cover the range of workers who are subject to stair pay contracts. So one, if the employer actually collects a debt from you, that's an unlawful kickback of wages to your employer. That's a violation of the FLSA. And two, even if the debt hasn't yet come due, none of the employees' wages are being paid free and clear. They're always subject to kickback unless the employee keeps working. And that's a condition on keeping your wages, and that violates, I think, the plain language of the regulation as well. The key limiting principle for wage and hour claims is that the FLSA does allow employers to take deductions from wages for things that are primarily for the benefit of the employee. So for example, under the FLSA, like voluntary housing deductions are fine, right? You can pay your employee less if you are giving them free housing. There are limitations on that, obviously, but it's allowed. Most stair pay contracts that we have seen are not primarily for the benefit of the employee. The training, and I think the question that you asked, Jonathan, got into this a little bit, but we see it for on-the-job training. Obviously, profits are primarily for the benefit of the employer. Equipment loans, immigration costs, job experience. I think the most common example that is sort of a weaker case under the Fair Labor Standards Act is like an employer paying for a graduate degree. But that's not usually what we're seeing. And so I've been talking about the Fair Labor Standards Act, but several state laws have similar analogs. So for example, in Colorado, I think Martha may talk about this later, but most traps are illegal in Colorado. California law requires employers to, I think the language is, indemnify employees for all losses incurred in direct consequence of the discharge of his or her duties. And I think that has a very similar effect to the FLSA. Massachusetts has a similar law. And I think, there are provisions like that in state laws all across the country.
Thanks, Rachel. And what you're describing about, all of these different ways and liquidated damages, and Jonathan mentioning, healthcare workers and nurses in this situation really also highlights the fact that there are, in addition to really damaging workers, there are public interests at play, like when nurses are trapped in their jobs, maybe they're not able to complain about unsafe working conditions or in inadequate staffing. So there are like serious public health and public safety concerns as well, which I think also may come into play in relation to the airline case, the pilot case.
For
Can you talk about that for a second, like the air safety issues?
Yeah, so we have a series of cases against smaller airlines, including the sort of puddle jumpers that you take when you're trying to go on an airplane to a place that like nobody's ever heard of before. Those planes are, those airlines are regulated under a sort of specific part of the Code of Federal Regulations that requires certain training, which makes sense, right? Like in order to this is probably good for all of us. In order to ferry passengers around, like the airlines need to make sure their pilots know how to do specific things. And if the airline doesn't do that, they get in trouble. The airlines that we've been suing have been charging their own pilots for that training that's required of the airline in order for the airline to function legally. If you leave one airline and go to another, you have to do that training all over again. So it's not transferable. And as a result, there are these pilots are making, in some cases, $12 an hour. And also have these contracts where they'll be paid, they'll owe like $20,000 in debt if they leave. And that's just, that's absolutely full stop not possible when you're making $12 an hour, particularly like, in the markets where they live, but really anywhere. And that leads to major safety issues because it makes pilots afraid to speak out, because if they lose their job, not only will they, lose their job, but they'll also owe tens of thousands of dollars in money they don't have. I think even, in the PetSmart case, these workers are grooming our pets. And there are really horrific stories out of PetSmart about things that happen to dogs when these low-wage workers are not adequately trained and can't stand up for themselves because they have this debt hanging over their heads.
Thanks, Rachel. And I don't want to linger too long on, pets, having horrible things done to them. So let's move on to Daniel. Daniel, as a lot of people with us today probably know, the FTC recently issued a rule banning non-competes and similar contracts like traps using its unfair competition powers. That's currently, the rule is being litigated, but that's what the rule would do. Do states have similar authority to combat traps and stay or pay contracts? And if so, what does that look like at the state level?
Yeah, that's a really, really great question. So the short answer is an unequivocal yes, to give some really positive news. So to give a little background, just as you alluded to, the FTC's landmark rule banning non-competes and other coercive contracts like traps utilizes the agency's congressionally delegated authority to regulate and prohibit what's known as unfair methods of competition. It's a really important phrase. And that's under, the actual phrasing is under Section 5 of the FTC Act. States possess the exact same legal tool to address the kind of contracts the FTC rules targets. Specifically, 12 states, which very interestingly enough covers the full gambit of political ideologies from politically conservative West Virginia to liberal Massachusetts, and collectively house more than 55 million people, have expressly written laws on their books that mirror the FTC's mandate and prohibit unfair methods of competition. Uniquely, too, these states empower their attorneys general, the chief law enforcement officer of the state, to issue administrative rules that can, again, similar to what the FCC is trying to do, categorically ban non-competes and traps without resorting to onerous, time-consuming, case-by-case litigation. And most critically, the state laws have these 12 states have language in their laws that include a clause that incorporates all of the jurisprudence and legal holdings surrounding the interpretation of unfair methods of competition from the FTC's law into their state laws. So what does that mean? That really means that the full legal thrust, the scope of the state law synchronizes with the federal counterparts. And unlike some aspects of law, the meaning of unfair methods of competition, especially from the Supreme Court, with a lot of cases from the 60s, is actually quite favorable. So these state lawmakers are really not working from scratch, and they actually have a lot of good to work with. Especially because what makes this really important is that a lot of these provisions, the state AGs haven't; these are untested. So it's good to have some sort of guidance, so they don't have to do a lot of reading and thinking about what does this mean? Where does this come from? What am I supposed to be looking at for my legal authority? So to get to the second part of your question is, what does it look like? So state AGs, basically just need to get to work, to put it bluntly. The primary reference point would actually be to see whether prior leadership has enacted similar rules under what's known as their unfair or deceptive act or practices provision. Now, fortunately, this provision is the provision for banning unfair methods of competition is in the same, it's part of the same law. So it follows the same regulatory track. So many of these 12 states have enacted rules under their unfair or deceptive act or practices provision. So really, they just need to follow that roadmap, if you will, for enacting a rule that bans non-competes and traps under their unfair methods of competition powers. And while the states have different requirements in terms of exactly how the state AGs can enact such a rule, they probably have their state counterparts to what's known as the Administrative Procedure Act. It's factual finding, proposed rule, comment period, etc. You know, the FTC's rule is basically an encyclopedia on nearly 600 pages. It provides a lot of factual background that the state AGs could use that does a lot of the fact finding for them. So yeah.
So just to follow up on a couple of things. One is you said state AGs need to get to work. I just, as an AG office alumna, I just need to say, like, they work really hard. But of course, there's always more. And most people that I know at AG's offices are really thrilled to have new tools and new creative ways of doing things. So I think people who may not be aware of these powers are going to be really happy to learn about them. And certainly all my time we spent in the New York AG's office, I never worked on regulations because, you know, we didn't have that within the labor authority. So AG's doing regulations. I mean, I assume also that separate and apart, you know, the question of like what states can do separate and apart from state AGs issuing regulations, there's obviously the ability of state legislatures to enact laws, and the FTC, everything related to the FTC rule really lays out a very complete evidentiary basis for states that want to do that.
Yeah.
I guess that was more of a comment than a question, as they say.
Which I fully agree with. Yeah, again,
Right.
I totally agree. You know, a lot of state AGs, especially some with the powers I outlined here. Some of them are really tiny states, like we're talking like Hawaii. You know, home to 700,000 people. That's not that many, which means their offices are quite small. So yeah, I'm totally sympathetic. But I will reemphasize, you know, the power's there. So if you have
Right.
If enforcers are looking to pull something off their plate and they're looking for something robust, this is an open opportunity for them and one they should consider.
So I'm going to get back to this question about the interplay of the FTC rule in the states, but I want to bring Candace into the conversation. So Candace, Mike talked in the beginning about consumer law and how consumer law also has a role to play in relation to this. And obviously this affects, you know, stay or pay contracts and traps affect people in their workplace. And so people initially think only, you know, about labor or employment law. But how could consumer laws be used to fight these stay or pay contracts or traps?
Thank you, Terry. It's a great question. And thank you, everybody, for joining us. So, like Mike mentioned earlier, consumer law is a great tool that can be used, and it's often underutilized. But when employers try to skate the line between consumer and employment law, they often make the case when making an argument against an employment law claim that this is for the employee's personal benefit, this is for their personal growth, for them to get a better job or gain skills that we're teaching them. And like Jonathan said earlier, it's often low quality training that is just not true. But when they make this claim, that's where consumer law can be an important tool, a unique tool to play against employers that try to make this argument. Every state has, for example, a consumer protection law, or what we call UDAPs, that can be enforced when employers make this argument that it's for personal use, for personal benefit. And so when they engage in deceptive acts, for example, to lure workers into a job with a low quality training and keep them there for 2 or more years, consumer law can come into play. When employers use traps, they treat traps like it's a credit. So they make workers take on this job, take on this credit as purchasing the training for their use to do their job. Workers are expected to satisfy this debt by staying on the job for whatever prescribed amount of time or reimburse their employer for the cost of training them, which, like others have stated, comes with the job. This comes with keeping people employed, making a living. But consumer protection law can offer that protection for workers on the other side of employment law. For example, there's a case that we often cite too, and we cite in our release that we dropped today. CRST Trucking was the case where the court found that CRST, the company that trains truck drivers, was in violation of Iowa Consumer Protection Law, or Iowa Consumer Fraud Act. Forgive me, I forget the full name. But CRST was requiring truckers to stay employed with CRST for 10 months or pay a $6,500 fee after finishing the truck training program. The court found that the training actually cost only between $1,400 and $2,500 per student. So CRST was charging these truck drivers, aspiring truck drivers, almost like 2.5 times the amount that it actually cost to train them. So they were in violation of the Consumer Protection Act in Iowa for that. On top of that, they also found that CRST could be in violation of the state usury law because they would send debt collection letters to employees and threaten to charge an 18% interest rate on the track. And so you're putting this fear into employees, like you said, Terry, they are afraid to leave the job. They are afraid of this debt that could be looming over them, maybe be sent to collections. And so consumer protection laws, or consumer laws in general, can protect workers on all fronts in addition to wage and hour laws and employment laws. These are exactly the type of actions that consumer laws were made to protect workers from. So state and local regulators have important tools that are already at their disposal, like the Iowa law, already at their disposal, already can be used and may already prevent traps. You just have to use them.
And so, Candace, a follow-up question on that, is this an either or kind of situation where you use either the consumer laws or employment laws, or is it potentially a both? I mean, this is a leading question, I should say. Or is it a both and situation where you could sort of plead in the alternative or plead both?
Yeah, I think like the alternative, you can use both. And we've had cases like PetSmart, like CRST, our case to Smooth Stack, where we played both. So definitely in the alternative or plead both, like stop them on all fronts type of thing. Yeah.
Thank you. And I'm gonna just now, if people who are listening have questions, you can feel free to put it into the Q&A. We're gonna go into, those were sort of longer answers. We're gonna go into like a little bit more sort of like quick peppery questions. Rachel, what makes a stay or pay contract a particularly good target under wage and hour laws? And I know there was a lawsuit that the USDOL recently filed. So if you want to talk about that as well.
Yeah, so I think that there's a couple of answers to that. I mean, one is that, like I said, the key question under the wage and hour laws is what the debt is for and whether it primarily benefits the employer. That said, that can look like a lot of different things. So with Smooth Stack, which Candace just mentioned, the debt was for like IT for basically training for an IT job that was geared very closely towards the company that the IT sort of employer wanted to staff you with. The Southern, our cases against Southern and Ameriflights, which are both airlines, are for this federally required training that's not transferable from employer to employer. And PetSmart, in addition to the debt for sort of Grooming Academy, which despite its academic name was not an academy and had, you know, no sort of license or transferable credential. So there was $5,000 in debt for that. There was also an additional $500 in debt for an equipment loan. for buying your own tools, buying your own grooming tools. And then we have a bunch of cases against nurse staffing companies that charge for like like pretty much anything you could possibly come up with. They will try to charge for, like we have lost profits, we have the cost of replacing an employee, immigration costs, all sorts of things. So I think government enforcers in particular, there are a couple of things I think that may be worth looking for. One is, so the PetSmart case we've spoken about a lot. That was a case that Towards Justice and Student Borrower Protection Center and Jubilee Law filed a few years ago. That case got compelled to arbitration. There's an arbitration provision there, and we just really weren't able to, convince the court not to enforce it, although we think it was unenforceable. So go ahead, Terry.
Can I just interject and say, I think this is something many of us have talked about, that where there's forced arbitration, public enforcers are not bound by forced arbitration. Unlike the workers, they didn't sign an arbitration provision. So Rachel, is that a category of case that you think would be a good potential case for, or is that specific PetSmart a case like that you think it would be ripe for public enforcement?
I think yes to both. I mean, these companies really rely on their arbitration agreements in order to stay insulated from enforcement, and public enforcers, sort of have a very straightforward way around that. So I think, companies with arbitration provisions generally are always really strong targets. The Department of Labor just filed a case against a sort of parallel case against SmoothStack, which is the staffing company that I mentioned. And one of the, I think, focuses of that case is that SmoothStack, and this happens a lot, we see this a lot in our litigation, employers will sort of leverage the threat of the debt to get really coercive and unfavorable settlement agreements out of, unrepresented employees. And so in SmoothStack, one of the things that they did was get these settlement agreements that were both not very good, and also had, I think, really broad confidentiality and non-disclosure provisions that made it very hard for us and also for the Department of Labor to actually talk to people who had been affected. So I think that's another thing where, generally there, I think, are a lot more restrictions on what you can keep people from saying to the government than what you can keep people from saying sort of in other contexts. So I think that's another circumstance in which public enforcement, I think, has the potential to be really helpful. And the Department of Labor's case against SmoothStack, I think, is, a really good step in that direction, and a really good sort of example of where the government really has, a lot more power than private litigants.
And that makes perfect sense. And I think that's true in, in a whole host of cases where there's forced arbitration. So how would government agencies that want to take on this work, how would they find workers who are subject to traps? And I'll just sort of open this up to all of you.
I think Rachel and I could piggyback off of this, but we've used social media, we've used things, online chat rooms, creating the Reddit, that chat room that we found people on Google. Sometimes we've had people reach out and be proactive. And
can
so,
go ahead.
Go ahead. I
was going to say, can you say, like, when you say social media or chat rooms, like,
LinkedIn.
How do you actually do that? Like, what are the search terms? And do you just sort of slide into a conversation where people are talking? Like how do you actually find these?
That's a great question. Yes, to clarify, we look up, like, it's my employer agreement. We use search terms and employee agreement or the training. Like, we just use key terms like that can pull up some of these discussions, because they're not going to say outright like this trap and I'm in the employer. So you have to be creative on the search terms that you use, or we look into specific companies that we have maybe heard of that use traps. like SmoothStack and other like subsidiaries of SmoothStack, if they have different companies, PetSmart, we look into different companies like that that may use those type of things. The racial too.
Yeah, also just, talk to organizations that are doing this work. I know, Towards Justice, and I'm sure Student Borrower Protection Center gets inquiries from people who have these kinds of agreements all the time. And, sometimes we're able to take the cases and help, but sometimes we can't, for, some of the reasons that I just identified. Forced arbitration is a big one. So I think, maintain a relationship with the organizations that are talking to workers about this stuff in your community, and reach out to us.
One other thing I'll just add, when you're having potential clients come to you, or you're in an agency, you have an intake process, adding a quick question on the intake form about whether your employer made you sign a contract saying you'd have to repay any costs, I think could be a really good way to find workers, and you'd be surprised by the number that have.
Yeah, I think that's so interesting. I was recently at a convening where we talked about how valuable it would be simply for agencies to have a question: did you sign an employment contract? Because so many workers don't know if they are subject to forced arbitration, if they signed a non-compete, if they signed a trap. And so when workers are coming in for wage and hour or discrimination or other kinds of cases, just routinely asking that question is something that could be useful. We have a question from Jarrett Haskovic, who's from the Arizona AG's office. And he asked, has anyone had any luck challenging traps as impermissible liquidated damages, basically a penalty, or as being unconscionable? So I'll throw that out to the group if anyone knows anything about that.
Yeah, I can answer that question. We brought that claim in several of our cases. We have had luck. We recently, the sort of most, I think, substantive decision that we've gotten so far from a federal court on our claims is in the Northern District of Texas, actually, in Ameriflight. And the court there held that we had pleaded a claim that the trap was an unlawful liquidated damages clause. We brought that claim, I think, also under Tennessee law and under Florida law. So yeah, we think that claim has a lot of promise, and have gotten good decisions on it.
I want to ask also, Rachel, following up on the question that you were answering about forced arbitration. If there's already a private lawsuit against an employer, like in PetSmart, other than forced arbitration, is there additional value to having a government action as well as the private or nonprofit litigation?
I think there definitely can be. I mean, I think it really, this isn't a super satisfying answer, but I think it sort of depends on the posture and the facts of the case. But we have, Towards Justice has found, particularly the Department of Labor, I think, has brought cases in two of the cases. So I mentioned the SmoothStack case that we filed. They have also brought a case in another stayer pay contract case that we have involving a nurse who had I think it was a liquidated damages provision in his contract. And then on top of that, he had an arbitration provision. So I guess this doesn't totally answer your question, because there was an arbitration provision, but he also had an arbitration provision where there was like a loser pays element to it. So he was liable, in addition to any liquidated damages, he was liable for attorney's fees and arbitration costs, which obviously get very, very expensive very fast. So that's a case where, Towards Justice and our partners on that case got a preliminary injunction against the arbitration moving forward. So there is, a case moving forward in court on behalf of private plaintiffs, and then the Department of Labor is also pursuing its own case, also under a Fair Labor Standards Act theory. So I do think that it can be really useful for for private and public cases to move forward sort of simultaneously, but it really sort of depends on the circumstances. And obviously an arbitration clause will change that, we'll sort of change that calculus. And like I said, in the SmoothStack case that the Department of Labor brought, there were these issues with this confidentiality provision where, again, the Department of Labor sort of has particular, authority to address that issue specifically that the private plaintiffs really would have had a much harder time with.
There's also the visibility, I think, too, of public enforcers bringing actions and sort of like the public messaging and sort of public, critique of the, or sanctioning in the negative way of the practices. So Jonathan, I want to dig in a little more depth into something. It's been sort of implicit in our conversation, and we've talked a little bit about how traps prevent workers from exercising their rights, but can you just spell that out a little bit more, how it prevents workers from exercising their wage and hour or unionizing or safety and health or other rights?
Yeah, well, I mean, it's pretty straightforward. If you are working under a contract that says you have to pay thousands or even tens of thousands of dollars if your job ends, you're going to feel really frightened to do much of anything. Speak up for your rights, even ask your supervisor for, I don't know, an accommodation for disability or maybe some help with doing your job, because this is always hanging over your head. Let alone going outside to a local or state or federal enforcement agency to complain that you're not being paid minimum wage or overtime, which is a whole another level of escalation, or for that matter, talk with your coworkers about trying to improve things in the workplace, because that if they fire you, many times that trap is immediately going to take effect. And you are going to have to not only deal with the fallout of not having an income anymore because you lost your job, but on top of that, you have to pay off this debt now. And so it has a major chilling effect, I think.
Thank you, Jonathan. I have a question for Daniel. We talked about the FTC rule a little bit, and I think there might be some tendency for people to think, well, the FTC passed, the FTC passed a final rule on this, so why do states or localities need to act? And could you talk a little about that? Like, does the FTC non-compete rule obviate the need for action at the state or local level? And just share your thoughts on that.
Yeah, that's a great question. So obviously the FTC's rule is profoundly important. It's an incredibly necessary policy that will liberate millions of workers from control of their employers and be able to use their talents to obtain a fair paying job in a respectful work environment. But relying on solely federal action, I think is unwise here. There's a couple of considerations. One, I think that's most glaring is that there are extensive legal challenges currently happening with the FTC's rule. And while I personally believe in extensive scholarship and just clear, plain statutory text support that the FTC has clear rulemaking authority to do what it is doing with non-competes and traps, some courts don't haven't agreed. There is one in particular in Texas that has said that the FTC doesn't have this authority. So the rule is not conclusive. Obviously, there are appeals. That the legal landscape, the number of legal steps left are many. So the battle is not over, but it's still not conclusive. So in this respect, what state AGs could do is really critical. Again, they have their own separate enforcement authority. They have their own separate legal authority to do what the FTC is trying to do. And again, as I alluded to earlier, some of these states have used their similar unfair or deceptive acts or practices rulemaking. So this is on a much more, or at least clearer legal ground, as it's been done previously in a similar way. The other thing is that even if in the case where the FTC's rule survives legal challenges, state laws can be enacted that are, or the state AG rules can be enacted that are stronger than the FTC's rules. So under that, traps are banned because they are considered functional non-competes, but they're not as strictly banned. They have to be a functional non-compete, and the rule's a little bit, it's not precisely clear. And the FTC can do a lot to clarify the actual extent. It can, it have issued guidance documents, do litigation to actually clarify precisely when that boundary is. But the state AGs can enact rules that are much stronger, literally working as another layer of the legal cake, so to speak, to protect workers from these kinds of contractual agreements.
And state legislatures as well. And you have the whole state enforcement mechanism. I think that's an important piece of hedging because, as the federal administration is more or less, supportive of workers, to have a whole state structure behind it as well. And state enforcement is incredibly powerful as well. We have a last question from the audience, which kind of dovetails also, the questioner dovetails with my final question for all of you. So the question from the audience is from Ron Ojeda, who's with the Denver Mayor's Office for Financial Empowerment. And he asks about whether there's any kind of right of rescission for new employees because people don't read the documents for a new job until they leave that first day. So that's kind of a quick consumer question. And then that's like a yes, no, that I'm sure you consumer people know off the top of your head. The other question that I want to ask all of you, and just very briefly, is if one of you could just answer, what about localities? We've talked, we've sort of focused on states a little bit more, but is this whole issue something that localities can take action on? So the right of rescission question, can anyone answer that quickly? Or is that not a quick question and maybe we should have someone type the answer?
I mean, I could just briefly say, there are some statutory provisions like if you're an older worker, for example, the Older Worker Benefit Protection Act, I think gives you a certain window to rescind a waiver of claims if you leave your job and are waiving certain claims you might have for discrimination. But other than that, I'm not aware of any ability to rescind after you've signed the contract.
And what about the question about localities? Localities can generally enact, unless they're preempted by their state, similar laws prohibiting non-competes, and prohibiting traps, or can they enforce their consumer laws to address traps? I'm seeing nods, and we're low on
quick answer is yes. Yes,
awesome.
They should.
Great, thank you. So I'm going to turn now. We're going to close out the Q&A and the discussion with our four panelists, and we are going to be joined by Martha Fulford, who is going to share some final thoughts before we have our closing. She is an assistant so thank you to our panelists. That was really great discussion. Martha is an assistant deputy attorney general in the Colorado AG's office, leading the office's civil rights team, including housing and worker protections. She's also the consumer credit administrator, enforcing laws related to consumer financial protections. Before joining the AG's office, she represented student loan borrowers in impact litigation against student loan servicers in the U.S. Department of Education, and also served in the legal division of the Consumer Financial Protection Bureau. Martha, please share your thoughts.
Thank you so much, Terry, and thank you to all of you for including me, and what a great panel, really addressing these important topics. So I get to sort of be the final call to action for our state and local partners. So what can we do? I actually think states are uniquely situated in this area. So as opposed to our federal partners who have an alphabet soup of agencies, there are 2 who do antitrust, many who do worker and consumer protections of various kinds. States are often a one-stop shop, which doesn't mean that we aren't siloed within our own office. So it's important to be thinking, if you're thinking about, okay, there's this problem in the world, these traps, what are the full suite of tools that we could bring to bear here? So consumer protection is one, but are you talking, if you're a consumer protection attorney like me, are you talking to your worker protection colleagues? Are you talking to the people who represent your labor division? Are you thinking about the full suite of tools that are available? And, Rachel highlighted some of these worker protections. Think about both. So SBPC and Torch Justice, as they mentioned earlier, have filed complaints really arguing in the alternative. This is a really powerful innovation that I think state AGs can also bring to bear. Another thing Terry mentioned that states can do is enact legislation, which is often very hard to do at the federal level. So Colorado has what we call the Restrictive Employment Agreements Act, which was passed in 2022, which specifically calls out traps. Traps are permitted in Colorado only if the training is distinct from normal on-the-job training. It's limited to the reasonable costs of the training, and it decreases over 2 years. So these kinds of requirements really lay down clear rules of the road for employers and for employees. And just this past session, the General Assembly gave our office additional rulemaking authority regarding the transferability or credentialing of the training. So, as Daniel mentioned, we're ready to get to work, both on the enforcement side and on the regulatory side, thinking about rulemaking in this area. The General Assembly also clarified that traps are covered by lending, consumer, student loan, and debt collection consumer protections. So again, just laying down these clarifications, setting out clear rules of the road. The panel also mentioned that state and local governments receive complaints. This is a really powerful tool for states to be thinking about what are we hearing from people in our communities. And it's important to make sure that folks know that your office is a place to turn when they're facing these kinds of contracts. Trusted partners, as Rachel mentioned, can also be a really important source of what's going on in your community as well. So I'd encourage all of the state enforcement folks on the call to think about using your full suite of authorities here, whether it's rulemaking if you have that authority or enforcement powers, particularly where workers might be barred by forced arbitration. You're not on your own on this either. Terry is the convener of an incredible community of public enforcers, and your colleagues across the country, including in Colorado, but all across the country, are resources if you're considering jumping into some of this work. So with that, I'll turn it back to Anastasia to close us out. Thanks so much.
Thank you, Martha, and thanks for giving us little calls to actions and things that people can do in order to start addressing this. Thank you also to all of the panelists for so much really good information. We know so often when workers are trying to address wage theft or health and safety problems or discrimination in the workplace, the employer community very blithely says, well, you should just go get another job. But what we're seeing is that they put these roadblocks in the way for workers even to do that, which makes it prohibitively, impossibly expensive for them to do it. So this is so important. Thank you, everyone, for sharing so much information. Thank you to everyone who called in for being engaged on this issue and thinking about how to help workers get away from these really dangerous traps. It's greatly appreciated, and we're really excited to see what kinds of state level actions people are able to take in order to help workers. In the last minute or so, I will just plug again that there's going to be a toolkit that will give you a lot of information and tools to be able to start taking action on these ideas, in addition to taking advantage of the expertise that you've heard on the call today. And I really recommend the blogs that were mentioned early on, hosted both on the National Employment Law Project site, my organization site, and the Student Borrower Protection site. Those blogs are both there. They're done by many of our panelists that were with us today, and they're really good background and fleshing out some of the ideas that are here. So again, I just want to thank everybody for participating, thank all of the panelists, and thank everybody for calling in, and wish you all a good rest of your day.